Madam Speaker, for the record, this morning I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk of Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me to present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem, and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts-martial and related matters, including the shadows approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the Clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126.1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it's not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honourable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the courts martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows. Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two. One in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemerere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this Parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this day, date, and year will go down as the official birthday of the dreaded military dictatorship in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names, in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Aneta Mao, Colonel Retired Dr. Kiza Warren Besige.
Honorable, I would never wish to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one